have gotten the same termination over what happened. Had Mr. Fleisch come to me in advance and said he was suffering from PTSD, we would have done something to help him out. But no matter what, once the criminal occurrences occurred, no matter who it was, whether they had been prior military or anything else, would have gotten the same outcome.
Okay. During the hearing, Mr. Flesch, you went over his pre-employment arrest record in detail, didn't you?
Yes, I did.
Okay. And sir, didn't you tell Mr. Flesch during that hearing, if this were a one-time incident, by God, I could walk you to the line?
I don't make that, but
What do you think that phrase means, walk you to the line?
if walked the line, and normally if I said something like that, then we could take and do something to help him out.
Okay. And keep him employed, right?
But with other people we've had with the same thing, we would not have kept them employed over this kind of an incident.
Okay. Did you tell Scott Flesch, if this were a one-time incident, by God, I could walk with you to the line?
There's a big possibility I'd have to listen to the tape, but I'll take your word on it.
Okay, and if you did say that, that would have meant, you know what? If this December 5th conduct was all we had, I would work with you. I would keep you employed and try to get you help.
I don't believe we could have kept him employed after what he did.
Well,
If I said it, I may have said it, but there's no way we could have kept Scott employed after what happened.
I'm telling you now, you said it. Well, we'll listen to the tape and we'll let the...
So I'll take your word that I'll say it on the tape.
Okay, so if you said it, that meant that you would, if this were a one-time incident and this previous history that Mr. Flesch had prior to joining the Sheriff's Department hadn't occurred and didn't exist,
Well,
that you would work with him.
Sheriff, I'm going to put an objection on the record. This question's been asked, I think, 3 times now and answered. The sheriff has said if he says it's on the tape, he'll accept it. I mean, we've answered it 3 times.
I'm not disputing whether or not it's on the tape with the witness. I'm just trying to get an understanding to me.
And he's answered the question, so.
I think it has been. Is there something else you want to know about it?
Well, I'm still unsure of the answer that he's giving, to be completely honest. May I ask a question one more time for clarification?
Want to use smaller words? What does he not understand?
I'm not sure that the witness's answer is clear enough for my purposes, sir.
I think it's the board's purposes, and if the board, if the board understands his answer, it's been asked 3 times and answered. If the board needs clarification, they can ask questions at the end.
Okay. You want one more shot at it? I don't mean to be flippant, but I think we've got it on record.
Okay, I'll move on. I don't need small words to be used. You told him that his previous arrests, his baggage, were too much and prevented you from changing your termination decision, didn't you?
Yes, sir.
Okay. So if the previous arrests hadn't occurred, didn't exist, you could have changed your termination decision.
Again, objection asked and answered.
I'm not asked this question, nor has he answered it. Just because you don't like this line of questioning is not a basis for
I'm
objection.
perfectly fine with your line of questioning, sir. I'm just trying to move it along.
Mr. Bush, I'd like to apologize for my flippant remark. That was uncalled for. But I do want to get what you want to get on the record and in an expeditious manner without badgering anybody. And I want you to have your shot to witness. And after that, we'll come to the point where we need to move on. Would you repeat that last question?
Sure, because it's not a question I'm not asking for.
All right, thank you.
You told him, Mr. Flesch, that his previous arrests prior to joining the Sheriff's Department were too much baggage and preventing you from changing your termination decision.
Yes, sir.
Okay. Now, does that mean that if this previous baggage didn't exist, that the possibility existed for you to change your termination decision?
Possibility, yes. Probability, no.
Now, during the termination hearing, Judge Candish asked that the determination on discipline be tabled pending the outcome of the criminal charges. Is that right?
Yes, sir.
And you refused that request?
Yes, sir.
Now, do you acknowledge that that was done in other cases, sir?
I'm sorry.
Do you acknowledge that that was done in other cases involving deputies being subject to
We
discipline?
don't always go on the criminal charges, we go on our investigation. The criminal charges and the personal conduct are two different, can be two different things.
But you would agree
They
that
can even go in and be totally exonerated, but at the same time, their conduct involved in the incident can create the issue where they're going to take disciplinary action against them anyway, which is whatever it may be.
my question is this. Would you agree with me that in instances other than Mr. Flesh, this situation, that the sheriff's office would postpone or delay the commencement of IAs pending the adjudication of criminal charges against the officer that are the subject of the internal investigation?
We have at times, yes.
Why was that done in Mr. Flesh's case?
We had, in that case, I mean, it's just sometimes we do it before, sometimes we do it after. It just depends on the circumstances of the case. How much information, how much evidence we have, and what kind of evidence.
Okay. And what about Mr. Flesh's situation? Led the sheriff's office to decline his request, whereas it had granted the same request in respect to other deputies.
Just from circumstances, I can't give you all the circumstances.
Is there any particular circumstance in Mr. Flesh's case that led you to deny that charge?
No, sir.
Is it true, sir, that his previous history of offenses prior to joining the sheriff's department were a motivating factor in your decision to deny the request?
They didn't help matters.
It didn't help matters. So it was a factor. Now, so in making your decision to terminate Mr. Flesh, you took into account in making that decision his history, in addition to the circumstances that are unfolded on December 5th, 2010.
Objection again, that's been asked and answered. You're just asking the same question a different way, Mr. Bush, with all due respect.
He's answered the question, I'm good. He answered it yes. Let me show you the letter that was marked. As Exhibit 10 to your deposition. The intent to terminate.
What deposition? You just need
I'm sorry.
Exhibit 10. Okay.
Exhibit 10, thank you. We've already discussed and recognized this. Sir, can you tell me where in this letter it advised Mr. Flesh that you were considering, you were going to consider his past history prior to joining the sheriff's department, his history of arrests and military misadventures, and deciding to terminate his employment?
We wouldn't be there.
I wouldn't be under there.
This is not the whole case. All this is the intent to let them know, and the whole internal affairs is in a different total file. And I mean, that's not it.
Well, that document is supposed to contain all the allegations against the witness, is it not?
This was the allegations for this immediate incident.
Before we give you just a moment, I'm trying to locate something. Sir, are you familiar with the merit system rules?
Pretty well.
I asked the board to take judicial notice of certain sections of the merit systems rules. And let me provide you a copy of what I submitted. Do you have a copy, Mr. Hall?
I'm fine now.
And let me refer you to the sections of this document First, 86-427B, that's going to be on page 66 of the merit system rules. That's it. Can you read that to yourself, sir? And I'll read it for the record. A dismissal shall be effective only after the employee has been presented with the reasons for dismissal in writing specifically and fully stated, and has been allowed a reasonable time to reply thereto in writing. You see that, sir?
Yes, sir.
And if you also look at 86-455F.
I'm sorry.
86-455F, which is going to be on page 73. Here. Specifically, I want to draw your attention to subsection 2 under section F. I'll read it for the record. A dismissal shall be effective only after the appointing authority has obtained concurrence of the legal department and the personnel director and has presented the employee with the reasons for the dismissal in writing specifically and fully stated, at least 3 days in advance of the proposed effective date. You see that, sir?
Yes, sir.
Now, you've already testified that Mr. Fletch's past played a role in your decision in terminating him. Why then did you not include that rationale, those reasons, his past employment, past pre-employment arrest history, in the letter that you provided to Mr. Fletch on February 14th, 2011?
Well, one thing, it's about like a trial when a judge looks at somebody's background and decides to sentence them. When they sentence people, they look at a background too, and it's not there. But the issue is I would have fired him for what he did on that day, notwithstanding what had happened in the past.